Hello, good night. This is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments so that I may answer your questions. Tonight, I have a great topic to talk to you about, and it is going to be going from the 2-year green card to the 10-year green card without your spouse. Yes, there are certain situations like this where you do have to remove the conditions on that temporary green card to get the 10-year green card, but you may be going through marital issues. You may be divorced by the time you're ready to apply for the 10-year, and you have to go it alone. There are ways to do that, and that's what I'm here to talk to you about tonight. But keep in mind that I'm also here to answer your immigration related questions. So put your questions in the comments starting now so that I can answer as they come in. So between what I'm talking about, Tug 1981, Happy New Year. Thanks so much. Wishing you a prosperous, safe, healthy 2022. And I'm wishing the same for everyone here who is tuning in tonight. Now, I'm also on YouTube, so I just want to remind you that I am here. I'm looking out for the comments. Go ahead and put your questions in the comments. I will answer. So let's talk about the 2-year green card. What is the 2-year green card? Now, when you are applying for permanent residence through marriage, and if at the time you have been approved for your 2-year permanent residence, you will get the 2-year green card. You'll get the 2-year green card if you've been married for less than 2 years. It's the 2-year period is like a probationary period where they want to make sure that this is a real marriage that you're entering into. And so when it comes around to the 1 year and 9-month mark, you'll have to start preparing to apply for the 10-year to remove the temporary conditions, kind of like the probationary period, probationary conditions on that card. French Blue, thanks so much. Now, for those of you who don't know, this is important because you may be applying for permanent residence through marriage now. You may be newlyweds. You may have been approved for the 2-year. I just want you to understand that this is not just going to be a process where you're going to go and renew your 2-year to the 10-year and that's going to be it. This is still a process. And it's going to be similar to the process that you had to go through when you obtained your 2-year green card. So usually to get past, thanks so much, French Blue. I appreciate the love and support and your encouragement. Now, one thing I want to note here is I'm on Instagram. That's where most of my content is. I usually come on this TikTok to do lives. However, I am on Instagram. That is where most of my content is released. So if you want to get more of those, come on over to Instagram, follow me there, where you will definitely get more tips. You will get more information, updates. So, Mohammed, I see you're repeatedly typing that question there. And the time that it takes is really going to depend on the service center. So look, if you go to uscis.gov, scroll down to check case processing times. You can click on that. Look up the California Service Center. You will see the range of time that they're taking. All right, keep putting those questions in the comments because I'm here to answer your immigration questions, and you can put your questions both in YouTube and on TikTok. Now, I have been talking about the 2-year green card. You get the 2-year green card when at the time you're being approved for the permanent residence, you've been married for less than 2 years. Now, what it means is that 1 year, between 1 year and 9 months, and within 90 days before your permanent resident card expires, you should be applying for a new permanent resident card. This would be a 10-year card. You have to jointly apply with your spouse. And the reason is they want to see that you're continuing to live in a bona fide marriage with your spouse. Now, if you don't, you must go ahead and jointly file. If you don't, then you're going to have a good reason why you can't. And this is the good reasons, the only reasons that you could apply for a waiver would be based on divorce, based on extreme hardship, or based on abuse or mistreatment or extreme cruelty. So those are three ways that you can apply. Latoya Plas, thanks so much. That you would be able to apply for an excuse to apply on your own. And I help my clients to obtain this. Very, very important that you explore your options and plan ahead so you can submit an effective, thorough waiver request in order to apply on your own. I'm going to pause for a minute to answer some questions. Quick question. I have an expired green card for 16 years. I was a child. So Bree Bell, if you are outside of the United States and your card has expired, if you've been outside of the United States for 365 days, it is presumed that you've abandoned permanent residence. And there is what's a special visa for returning residents. But you will have to show good reason why you stayed outside of the United States and that you continue to maintain ties in the United States. So that is touching on a more complex topic, and it really comes down to your particular circumstances. So you should call, schedule a consultation, and we can talk. How long does an I-130 for a child under 21 take to be approved after naturalization? So the processing time is 18 to 24 months, could be less, could be more T-tapping. And so that is, I can only give you a range of time. I wouldn't be able to tell you after your naturalization how long it's going to take. It still has to go by the processing times for I-130s. How do I go about trying to get it back? So there is what's called an SB1 visa, but this only fits within certain circumstances, and 16 years after the fact is definitely a lot of time and may present an uphill battle there. You could also apply based on any kind of relationship that you have with a family member who can apply for you to come back. So Bree Bell, please let me know how we can talk. I'm really interested in fixing this. So I am a U.S. immigration attorney, and so I do consultations, and that is how we're going to discuss your matter, where you will get personal legal advice. I will evaluate your situation in detail and then advise accordingly. You can do that by going to the link in my bio. It's going to take you to the page where you can schedule your own appointment, or you can click on the website button. When you go to the website button, it's going to give you the phone number is there, the contact form is there to complete, and the online chat. There is a scheduling coordinator who's available up until 11 p.m. You can also call, and my phone number is all over my videos. It's 561-405-4889. If your wife is in the US, what chance I got to get visit or visitor's visa? It really depends on your circumstances. When it comes down to the visitor's visa, you have to show that you have a strong ties to your home country that would make you go back after a temporary visit. But it depends on your wife's status. Is your wife a US citizen? Is your wife a resident? That may be a way for you to get permanent residence. So call, schedule a consultation, and we can talk about your situation. My husband applied for his children in Liberia. Do they all are they required for a DNA test? It depends. So Tug 1981, it depends on the circumstances. In some cases, if he's not on the birth certificate, that may warrant a DNA test. And usually they will order the test if they want more information. So keep putting those questions in the comments. Now, why is it so important to talk about this topic of going from a 2-year green card to a 10-year green card without the spouse? Because generally the spouse is required to jointly file for you. But guess what? Life is not perfect, and a marriage definitely isn't perfect, and things happen. Some of those things that happen is divorce, abuse, or separation. Right. And in situations like that, guess what? When it comes around to applying for going from the 2-year to the 10-year, and it comes around to application time, the spouse isn't always there to jointly file with the applicant. And that can bring some distress and uncertainty. But this is where this is what I want to break down for you, is that there is a way to still apply on your own, but you have to fully understand how this works, and you have to get the help that you need. As long as you can apply for this waiver at any time. So say it's been a year after you've gotten your 2-year, you got divorced. That happens, and sometimes it's in your best interest to get a divorce. It's something that the both of you feel is in your best interest. If that is the case, you can go ahead and submit your application and submit a waiver request. You can't just put that you're divorced. You have to proactively put that you're applying for a waiver, so that they know that you're applying on your own. When you are, or if say you're still with your spouse, but you don't trust them to apply with you because maybe they're abusive, maybe they are refusing to apply for you, maybe they are unavailable right now. In a case like that, first of all, you could do it based on abuse or mistreatment. But if they say they just aren't available and divorce doesn't apply, abuse doesn't apply, then it would be based on extreme hardship to show that you would experience more hardship than the average if you lost your status. So there are options available. And one of the biggest mistakes that I see people make is that if the spouse is not available to jointly apply, or if the spouse stops being available after they've applied together, they give up and they say, okay, I guess I'm destined to live in the US without renewing and just face the consequences, or they go home. And that is not something that's warranted. There are options available. You just have to get the help you need to make it possible. And one thing too is that when you do that, so say you decide, say you didn't know about this. I have seen individuals who didn't know that they could go ahead and apply for a waiver to apply on their own without the spouse. And they go ahead and wait. They don't apply. They miss the deadline to reapply for the 10-year. And then what happens is they get a notice to appear in immigration court. And that means that you are officially going through deportation proceedings. And that can be scary. That can be uncertain. Nobody wants to be in court. Thanks so much for the love. Nobody wants to be in court defending against deportation when you've built a life in the United States, when you've built a family, when you have a career, when you've built your education here. It's not fair, and it should not go that far. But that is something that I have had to do, and it gets more complicated to defend somebody in immigration court. It gets more expensive because now it's not only removing the conditions, but it is deportation proceedings, and it doesn't have to go that far. So if you need assistance, you're in a situation where you are not applying with your spouse, even if you're applying with your spouse, it's always best to get legal representation through your process. I'm going to stop for a minute to answer questions. Can you explain about the C09P EAD? So the C09 is based on the work permit based on adjustment of status, and the P stands for the travel document. So you sometimes when you see the C09P, it means that at the same time there it's going to be a combo card where you're going to have the travel document on along with the work permit on the same card. Can a new green card holder get married to someone for them to get their green card? Now, keep in mind that this can't be a business arrangement. There's no such thing as a business marriage. That's called fraud. That's called marriage fraud, and it has severe consequences. However, if you're in a bona fide relationship and you want to get married, then a green card holder can get married to their spouse, and they have every right to sponsor their spouse for them to get permanent residence. There are situations though where you have to wait. For example, if you got married to someone who got you your green card, then you divorce right away, at that point that is going to be assumed that this is marriage fraud if you now hop on and get married to someone else right away for them to get their permanent residence. Usually it's 5 years. If you are within the 5-year period, you're going to have to show by clear and convincing evidence that not only your current marriage is bona fide, but that your previous marriage was bona fide. So very important that you take those into consideration, get legal advice, get legal representation to fully understand the implications, and to go ahead and do it right so you can be successful in your process. Can a parent who is a permanent resident sponsor her married children? I appreciate this question. No, a parent cannot sponsor their married children. Only a U.S. citizen can sponsor married children. And for a U.S. citizen to sponsor their married children is taking about 12 years. Can your husband file for you if he doesn't have a job? Yes, he can. It's possible. But what would happen is if he's not working and he's making zero income, he will have to have a co-sponsor to show their income as long as they meet the income requirements to be able to help out with the sponsorship. Smiles, you're welcome. NDNT Dog, thanks for the follow. I appreciate it. These are great questions. Keep putting the questions in the comments. I will continue to answer your questions. Now, I am talking about going from the 2-year green card to the 10-year green card without a spouse. I'm here on YouTube and I'm here on TikTok to answer your questions at the same time. So now is your time to put any immigration related questions in the comments. It does not have to be related to the topic that I'm talking about. Now, I have been talking about the waiver though, without the spouse. How can you apply for this waiver? The application does allow for the waiver, but keep in mind that the waiver is not something that you just do in a one sentence. Please, can you grant me the waiver to apply by myself? You still have to make a case as to why you are deserving of the waiver. That's what I help my clients with. What I want you to take away from this, though, is that you do have options to apply on your own, that you cannot underestimate the process, and that this is something that can be done at any time as long as you haven't gotten a notice to appear. So for example, say you missed the deadline, say you're watching right now on the live and you realize that, wait a minute, I have options to apply without my spouse, but your deadline to apply your 2-year green card has already expired. Usually you'll have to show a good reason for missing that deadline. And there is a small window where you can still go ahead and apply. And in some cases, the USCIS will, and this is the Immigration Service, will still accept your application and will still process it as long as it hasn't gone to immigration court yet. Even in cases where your case was denied and you really would like to try again, there is that window of opportunity where, and I don't recommend you do this on your own. At the point you get a denial, it's time to make sure you get legal representation. But there is in some cases a small window where you can reapply quickly before a notice to appear in immigration court is issued, and they will adjudicate it. And if something is different that warrants an approval, they go ahead and do that. And it helps you to avoid the problem of defending against deportation. Because if you miss the deadline to apply to renew your 2-year to the 10-year, and you don't try to apply, of course, to submit a proper application, you will get a notice to appear. And that means you're being removed. And so you have to go through proceedings. Nobody wants to be in front of an immigration judge doing that. Let's see. Okay, I'm just looking to see if any more questions have come in. I don't see any more questions. So I am going to call it a night, but I wanted to let you know about these options, the importance of applying within the deadline, the importance of making sure that you have the legal advice you need, the representation to go through our successful process. Christine Sukram, nice to see you. How can someone obtain a green card if they overstay their visa and is not married? So it depends. That is a very, very loaded question, just because there are so many different ways, and those ways though depend on your circumstances. One can't just go from being out of status or overstaying to getting their permanent residence. There has to be some circumstances. So for example, if you were the victim of trafficking, if you're the victim of a crime, if you're filing for asylum, while those give you temporary status at first, they can eventually lead to permanent residence. Also, if you overstayed and you're the immediate relative of a U.S. citizen, like the parent of a U.S. citizen who's 21, or you are the son or daughter of a U.S. citizen who is under 21 and unmarried. So Bernice, no. So nothing on DACA today. All right, so I am going to be heading on over to French Blue. You're welcome, and I'm looking forward to, thank you for that. Now I'm going to be heading on over to Instagram to continue the live there. You can go to The Immigration Attorney on Instagram. I'll also be on Facebook. Facebook is ST Law Office. If you go to ST Law Office, you can join me on the live on Facebook as well. If you want to follow me on other channels, I'm on YouTube, I'm The Immigration Attorney. I'm on Instagram, I'm The Immigration Attorney. You can hop on there right now to see me there and to continue your questions. I am on YouTube, Facebook, and Instagram. So any one of those will be platforms where you'll see me. If you don't see me here, you'll see me on Instagram, you'll see me on YouTube, you'll see me on Facebook. So thanks so much. I appreciate the love. Antonio Suraj Paul. So you said, what about filing for asylum? It really comes down to, are you afraid of going back to your home country because you fear harm in any way because of who you are, or the group basically the group you identify with? Do you identify with a group that is being targeted in your country? For example, based on religion, if you are a part of a religion where members of that religion are being arrested, they're being beaten, they're being killed, that could be. Vanitag, can you transition to a green card from an O1 visa? That is a possibility. The O1 visa is an extraordinary ability green card. And if you do prove that you have extraordinary ability to get the O1, it may be a possibility to apply for the extraordinary ability permanent resident. The good thing about the O1 is that it's a dual intent. So meaning that you can actually come to the United States and you could having the intention to get permanent residence while being on the O1 here in the US will not cause your O1 visa to be revoked. Vanitag, I do help clients to obtain permanent residence through extraordinary ability. So you can always contact me, schedule a consultation, and we can talk more about that. All right, so I am going to go on to Instagram right now and Facebook. I'm the immigration attorney, same as here on YouTube, same as here on TikTok. You can just hop on over there, go to the profile. You can click on the Instagram button there, or you can click on the link and in my profile or bio, and you will see the Instagram button there. You can click that, go there. Now, remember, the information I gave you tonight is not personal legal advice. It's general information. So you shouldn't act on this unless you have personal legal advice and representation. That's where it's very important to schedule the consultation with me. You can do that by going to the link in my bio, and it will take you to the page with all the listings of my channels and website, as well as a button to schedule your own appointment. When you apply for VAWA, do you get a temporary or permanent resident card if you are approved? So you get status. So first you get status that allows you to get a work permit, and then you can apply for permanent residence. You can then apply, or it's gonna continue on to the permanent residence process. I help clients to get VAWA, so Passion of Beauty too. Give me a call, schedule a consultation, and we can talk more about that. I did a biometrics a month ago. What's the wait time? So it's hard to tell what the wait time is. It's all over the place right now. What are the first steps to marrying someone from another country and to bring them here? So that is a lot for the night. What I can tell you is it depends on, are they here? Are they in the other country? What's going on with your relative? How do they qualify? If they are going through adjustment of status, it's a matter of filing. The adjustment of status is where they're here and you want them to stay here while they're applying. You can file the petition. So the first is usually filing a petition with the evidence to show bona fide marriage. So NDNT dog, go ahead, schedule a consultation. There is a scheduling coordinator who's available. Now, if you want to catch a replay of this live, go to my YouTube channel. You will see it there. So if you are just joining in, because I'm about to leave, so if you're just joining in, go to YouTube. I'm the immigration attorney. Go there and you will be able to catch the live. It's gonna be the last video that's posted. So go ahead and you can rewatch the live there about the topic I came to talk about tonight. Thanks so much, everyone. I will see you tomorrow. I'm here every night around 9 p.m. Eastern time to take your questions and also to come with a good topic. So thanks for your good questions. I hope to see you tomorrow or speak with you in a consultation or see you in a minute on Instagram or Facebook. Have a good night.